Hello and welcome. This is Case in Point. I'm Joanne Joseph. Great to be with you this evening. The National Prosecuting Authority gives IDAC a drastic overhaul after endless scandals and revelations of abuse of authority.
All employees in IDAC will undergo lifestyle audit as a matter of agency.
And later, are the deep-seated problems fixable in 6 months, as Advocate Andy Mutibi has promised?
You will be shocked at the amount of prosecutors and employees, admin staff from IDAC that are receiving counselling.
The National Prosecuting Authority is about to give its corruption-fighting wing, the Investigative Directorate Against Corruption, a drastic overhaul. The country is none the wiser about who will succeed Andrea Johnson to fix IDAC, although we'll likely know next week. At the media briefing this evening, both Justice Minister Mamoloko Kubai and National Director of Public Prosecutions Andy Mutibi announced lifestyle and skills audits and vetting for IDAC employees, strengthening checks and balances to eliminate abuse of power and conflicts of interest. The organisation, now just 18 months old, was established to ensure the law is upheld. But today, new measures were announced to hold it to that promise. Let's take a look at what the Minister and NDPP had to say.
Under Human Resource Management and Development, the branch has been tasked to commence with the process of analyzing the job profiles against CVs of the people who are holding the positions in IDAC. This analysis of all 146 staff members in IDAC will be completed by the 14th of August 2026. All employees in IDAC will undergo lifestyle audit as a matter of agency. A skilled, experienced investigator is being appointed by the SIU to be seconded to the NPA to conduct a full case audit on all cases. In the interim, the NPS is finalizing the consideration of the CID cases enrollment. All Section 28, 1 and 13 authorization will be evaluated against mandate, intake criteria and referral mechanisms. There will be an evaluation of all cases currently on the court roll to ensure that people are correctly charged.
All those where there is evidence pointing to wrongdoing, they will be held to account. That is why you have seen, the immediate suspensions that has kicked in, those that we have referred to. And everyone where there's evidence pointing to wrongdoing, there will be consequence management. We are following on the Madlanga Commission, and we do get information that, amongst others, enables us to identify those that we need to act on. So the accountability spectrum, and the list may not be exhaustive. Right? We hold you accountable as an employee, right? And you know that Advocate Johnson has resigned. That obviates the question of holding her accountable as an employee. That would have required an inquiry and. But the resignation, as we always say, and we have said that even when we were at SIU, that those that are found wanting and those that have contributed to wrongdoing will be held to account even though they've resigned.
All right, we're coming right back to this IDAC story in a moment. But of course, we need to just recap the breaking news that we're bringing you on the channel at this hour. Reporter Kenny Mapanga having covered this story quite extensively. And Kenny, I understand that in the last few minutes, you have had some important breaking news about the work of the impeachment committee and whether that may or may not end up in the Concord.
Yes, we know that the impeachment committee and several other parties, political parties that are involved in the work of the impeachment committee, have turned to the Constitutional Court for clarity on this interim interdict that at least pauses the substantive portion of the work pending the review in September, and they're seeking clarity on the Constitutional Court's order against that particular interim order. And we see that the Constitutional Court has since issued directions this afternoon, which ask the parties that wish to oppose the matter to file by the 5th of August. So usually this is some kind of sign that the matter is moving forward in the Constitutional Court. If there was nothing or no case or no merits to what is being sought from the Constitutional Court, you would usually see an order refusing that particular appeal bid. But the fact that it is advancing and there are directions and many more could be issued if the Chief Justice chooses to do so, it means that the matter is going forward, and likely there could be a sign of this matter seeking clarity in the Constitutional Court.
Kenny, thanks for watching that breaking story for us, and no doubt you'll continue to keep your eye on it there. Well, joining us to discuss this further are former Scorpion spokesperson, this is the IDAC matter, of course, Sipho Ngwema, the Law and Governance Academy of Southern Africa advocate, Lauren Kahn, and attorney Nkabinde Inquiry, all of whom join us online. You've already seen our SABC News reporter, Kenny Mapanga, with us in studio. So Kenny, let me bring it back to you at this point. Some radical reform proposed within the IDAC. When they talk about processes being strengthened and services being improved, what do you think that's going to translate to in practice?
Well, if we look at some of the testimony before the Madlanga Commission, I'm not sure that all of it can be placed on the structure that is IDAC. Of course, there have been some discrepancies or flaws realized in the fact that this is a powerful institution that actually doesn't have the checks and balances in how they exercise the powers that are afforded to them. But in this instance, where there have been several red flags raised against IDAC and its operational methods, this seems to be an issue that could lean more towards the terms of reference of the Commission and not so much of the issue of the historical political interference that we've seen before in the NPA, because what we see from the testimony is that majority of these parties understood the law. The issue here was the subversion of the powers afforded to them in terms of the legislation in order to serve allegedly certain interests. That is where the flaws are. It's about ensuring that that subversion cannot take place if an actor chooses to do so. So the structure is there. It's been allegedly manipulated. That's what the evidence suggests. So such as if you get a Section 27 referral, in this instance, you're seeing a scenario where it is alleged that Advocate Johnson may have used the authorization powers afforded to her to basically hide under a preliminary investigation in order to launch a full-blown investigation against certain generals based off of a scant Section 27 referral affidavit that actually didn't meet the constitutional requirements.
So, Advocate Kahn, when officials talk about the need for policy and legislative review, what are they actually saying needs to change about the way IDAC is being run right now?
Hi, everyone, and thank you so much for having me, albeit virtually, Joanne and colleagues. So your question regarding policy and legislative review, if I may, I mean, it's very broad, but very, very significant. And I think this is something that perhaps is never ending. Legislation, as you know, is always responsive to context, and as is policy. And I think that perhaps maybe just to build off what my fellow speaker has just said regarding, we can't always place all the emphasis on structure, but structure is nonetheless important. And I think it is vital that we reflect upon the fact that just having a permanent IDAC, which we did not have in, say, 2023, it only came into operation as a permanent statutory body in 2024, is of course a structural improvement. And while of course these revelations are in principle disturbing, what was just said is vital. It's about alleged manipulation of the evidence, and at this point we can't put the cart before the horse. So I think it's important, just if I may, Joanne, and forgive me if I'm deviating slightly from your question here, just to state that I think in and of itself what we see here is also some degree of promise insofar as there is movement in terms of structural reform. Whether or not we need more movement, obviously there's much more civic momentum now around the need for the establishment of a permanent anti-corruption body, as has long been advocated for, housed within Chapter 9 of the Constitution. But that does not, to my mind, negate the need for the IDAC. Of course, the point just made regarding the terms of reference, albeit of the Commission, as I understand it. These things are vital because they're the framing in terms of structure and policy. To go back to your question, but I think equally what your question alludes to is the fact that despite the depressing state of affairs in this country, which is, it's everywhere, there is still improvement and there is still movement, and that for me is the biggest thing.
Right. Mr. Bazana, how important is it going to be to vet and conduct lifestyle audits on every IDAC employee?
Good evening, and thank you so much for having me. I think it is quite important when we look at what has been revealed thus far in the commission. We are seeing that there's certain people that were gaining or likely gaining certain kind of rewards for having behaved in a certain manner, or perhaps investigating matters in a manner that is untoward, especially in terms of what their own roles that they hold within the IDAC wanted them to do, you know what I mean? And as a result, with that being said, with this lifestyle audit, perhaps it may lead to the investigations showing that perhaps the money trail, for example, when you do a Section 204 application in terms of the Criminal Procedure Act, it will show us where the money probably came from and why it is that people are living the way that they are. And if indeed this money trail then shows us that indeed there was some sort of corruption, fraud, or any sort of misrepresentation that happened that led us to where we are at this particular moment.
So Kenny, we're going to see all IDAC cases on the court roll reevaluated as well. Do we have a sense of how mammoth a task that is going to be?
Well, we do know that the cases that are of interest are the crime intelligence cases. So that would be the Mokwele matter and, of course, the Medicare 24 fraud case. We already know that with the Mokwele matter, because it actually didn't even meet the requirements of a Section 27 referral and could have been taken to court on allegedly a manufactured statement, because we do see that the Section 27 that Ms. Ramsamy would have had is not the one that is allegedly currently before court. That matter has since been provisionally withdrawn. And of course, we now have the Medicare 24 fraud case, which Ramsamy has shed light on. And the evidence is pointing to a scenario where there was a rush to get the general to court without substantiating the evidence. And that is the kind of concern that is raised by the powers that are afforded to this particular unit. They have both the investigative and prosecutorial powers, and they can subpoena almost anything under that prelim investigation. And that is how it's easy to manipulate those powers and lead to an abuse where you get cases before courts that actually shouldn't be there. And then you have a unit such as IDAC, which is designed for high-level, complex corruption cases. You don't see it moving or advancing in that particular area, but seemingly finds itself in the middle of SAP's factional wars.
So, Mr. Bazana, I'm wondering, in your opinion, whether it's possible that this just isn't an IDAC problem alone, but more likely just an NPA problem in general, in which a poor culture emanating from Shamila Batohi's governance through to Andrea Johnson's leadership has infected the entire organization, including IDAC.
You know what? It's interesting you should phrase it that way, because, for example, with my background, I would have started with legal aid, and as with legal aid practitioners, we work very closely with the NPA because we're in court literally every day with the NPA. And as a result, you get to see firsthand what happens with regard to investigations and dockets. You get to see the frustrations that the senior public prosecutors, when we make representations to them, go through, what the control prosecutors go through. And then when they can't solve the issue, when it goes to the DPP and all the way up to the NDPP, you realize that there's really a serious issue or a lack of communication, or alternatively, a lack of knowledge with regard to whatever query that you're going to do. Because what you get to see as or when you're in court every day, you realize that certain aspects of the Criminal Procedure Act or even the latest case law is not readily available to our prosecutors. So with that, when it comes to investigations that are supposed to do with regard to their matters, they are quite limited in what they do. So that when you make representations to them with regard to any facet of the law of that or that particular crime, an element of that particular crime, you realize there's so much that is missing in between. So with you saying that or asking that question, rather, it actually does say to me that there is a problem beyond IDAC and beyond just NPA. It comes with the whole justice system, in that I feel with the cases as they develop the law with each day, it is not brought into the institutions, and the people who are tasked to bring this information to the people or bring justice forward don't seem to grasp what needs to be done. As you can see with the questioning in the Madlanga Commission, that certain sections that are bound to the head of IDAC, she didn't know what they were all about. So that is very scary, actually.
All right, so we're going to take a short break right now. When we come back, we're going to look at the relation between what we're seeing happen right now at IDAC and the Madlanga Commission. Would it all have come out were it not for the Madlanga Commission? We'll find out right after this. Welcome back. The Madlanga Commission has played a pivotal role in unearthing untoward behaviour at IDAC. Let's take a look at just one moment when Andrea Johnson came undone in response to the Commission's line of questioning.
Real intention was never to get a successful prosecution of corruption, or a successful prosecution that comes under PRECA. That was never the real intention. In my view, the intention was, as I say, get him arrested with the spectacle that comes with it, get him charged with a consequence that naturally will follow, which is the minister, and hopefully even he, National Commissioner, would say it's untenable for me to remain in this position while I'm undergoing a criminal trial.
I accept that this matter, he should be separated, but at no stage, Chair, was there an intention to embarrass. I can understand the optics thereof, but at no stage in the charging of Commissioner Masemola was there an intention that he be embarrassed. At no stage did any of these cases start on the basis of wanting to target any individual, even those that I mentioned. We dealt with the investigations. In the course of these 2 days of engagements, and in the manner in which we have engaged, we would have to accept that we could have done things differently and or could have done things better. But that does not in itself make it a witch hunt.
Well, we lost our line to Sipho Ngwema a little bit earlier on, so I want to bring him into the conversation right now. Mr. Ngwema, one has to wonder, if we didn't have a Madlanga Commission, whether the rot at IDAC would have gone undiscovered for a length of time.
Thanks, Joanne, and good evening to the viewers. Look, it depends, because also the system should have checks and balances. But of course, there's no doubt that these matters would have gone to court and some of these things would have been revealed in court. But I think what is important is the fact that we need to look whether or not the structures that are there, do they have checks and balances? And I think the announcement by the Minister and the National Director this afternoon is very important, but I think we should wait for the Madlanga Commission itself to complete, so that it comes with the findings and recommendations, because I think I like the line of questioning of the commissioners, and I know people at IDAC in terms of their capabilities, whether or not some of the things that the commissioners are suspecting were not, but I have no doubt that it was a matter of time in one way or the other, given the systems that we have, given the strength of the criminal justice system, that there is no way that some of the things that are coming up would not have come at a later stage.
So that's interesting. And of course, a moment ago, Ms. Dubazana was referring to not necessarily just a failure at IDAC or the NPA, but the entire justice system that is overseeing these operations in the first place. Mr. Ngwema, we remember Andrea Johnson's testimony before Parliament's ad hoc committee, for example. How is it possible that committee was not able to get the same answers out of Andrea Johnson that the Madlanga Commission did?
My understanding and watching the committee itself, remember, those are not lawyers. They are not used to cross-examination, but also they've got their own self-interest. And I think some of the things are coming up now. So politicians, by their nature, they're partisan, they're looking at their own interest, and therefore they could not have gone as deep as the Madlanga Commission has done. You have now our best advocates cross-examining witnesses. I think there's a good investigative capacity that the commission has versus what the ad hoc committee has on the other side. So you could see how information was handled, how questions were being probed, follow-up questions, the coordination between the commissioners in terms of what they had to ask. So the other ones are policymakers. They are not lawyers. They are not investigators. But the other ones, this is their skill. These are the people that are needed in the system. And fortunately, these are the checks and balances that the system has. And I think it should not escape all of us that even the commission itself is part of the criminal justice system. And I think the system has ways, because I think we should worry more if the system doesn't have these checks and balances, which can give us an opportunity to see what we are seeing now. And I think when leaders are held to account, I think all of us should be happy with the fact that at least there are a huge part of our systems that are working. And I think this is not the last time. Many are going to happen, but individuals come and go. As long as the system can prove to us, as it is doing now, that is able to recorrect and is able to be tested, but see these gaps that are within that system so that it can be able to improve. And I think the announcements today mean that improvements have to be made, but I still await the commission's finding and recommendation in terms of what more can be done. But there's no doubt about the fact that they need more capacity, they need more resources, because this kind of an elite structure or unit, it needs far more training for people to be able to deal with the tests that are going to face as they are facing them now.
Yeah, I think you're making a very important point there that I want to come back to a little bit later on. Advocate Khan, the Minister also alluded to the fact that, actually it was the NDPP, that all IDAC cases on the court roll are going to be re-evaluated. How mammoth a task is that likely to be?
I mean,
that's a huge task. I mean,
sorry, is that
sorry, Mr. Ngwema, that was one for Advocate Khan.
Oh, sorry, I'm sorry about that.
I'm happy for Mr. Ngwema to take it. It's quite speculative, and he probably knows more in that respect than me. But I mean, sure, all IDAC cases, yeah. I mean, that's a mammoth ask, Joanne, and but it's important, you know. And I think that as my colleague here has just said, at the end of the day, these are the checks within the checks. It's about an ecosystem of checks and balances. And just to go back to your original point about the but-for, you know, we've got this Madlanga Commission of Inquiry, which is the first commission of inquiry ever to have such extensive terms of reference. And I think this is actually, you know, it's an extremely good thing. We've seen vast amounts of taxpayers' money wasted upon commissions of inquiry that make you know, proposals and recommendations based on what is ultimately a truth-seeking mission, and therefore in and of itself a public good. And then those are left to gather dust. And as you know, as was just said, you know, the commission is, I wouldn't say part of the criminal justice system per se, but at the end of the day, insofar as those prima facie findings of wrongdoing, ultimately once they are reached, insofar as they are found to be there is found to be wrongdoing, that ought to at least feed into a then independent investigation. And insofar as there needs to be a fresh start now, I mean, this does raise questions about capacity and resources and so forth, but I can't speculate. All I can say is that at least there is movement, and just to also echo the point that you made about the but-for, you know, we need to look at the fact that it's a tremendous thing in a way sometimes to sort of step back from the crisis and look at the flip side of the coin, to say that we have a commission of inquiry that is not a paper tiger, that is indeed able to make recommendations that, as per its terms of reference, that must be taken seriously and of course still be treated independently. And of course, you know, one can't know, everyone's checking everybody else. So, I mean, you had on earlier, the strip was who guards the guardians. I mean, the guardians, we've got an ecosystem of guardians, and we've got the courts, and of course we've got appointment mechanisms, and we've got, you know, this in and of itself is accountability in action. So I'm trying to bring a positive spin the best I can.
I see that.
But just to answer your question about the, you know, all these IDAC cases, I'm not going to speculate on that, but I am going to say that if insofar as things need to be done afresh, and we know that our constitutional court has affirmed this, in relation to the so-called "Please Call Me" judgment, it was Justice Madlanga's quite seminal swan song of a constitutional court judgment, where it was found that the prior court was so egregiously wrong on the law that it wasn't about just it was like go back to the drawing board with an entirely fresh bench, and because of judicial error. So we can all err, and at the end of the day, as has just been said, it's not about necessarily, of course, the people that occupy the office being people of, as has been reiterated, expertise and integrity and courageous leadership. That's vital, but the institution itself must be robust enough to withstand changes in personnel and leadership.
Right. Mr. Bazana, of course, the minister also alluded to the fact that she'd received some concerning reports. I think it was last year sometime. She called in the NDPP at that point. She also asked Andrea Johnson to explain herself. Did the minister's intervention go far enough in that regard?
I would hope that it has. I hope that it has led to a point wherein people who are in leadership are going to go back and do their own checks and balances against what they should have done in the first place. So if we look at, for example, the kinds of questions that have been put forth in the Madlanga Commission to the people who've been there, especially people who are supposedly officers of the court, supposedly people who are well knowledgeable in the law, what should have happened is that if a docket or if information is placed before you, what do you need to do? You need to go through it with the various applicable laws. If it's a crime of fraud, you need to go through the elements of the crime. It's misrepresentation of the fact and the unlawfulness of all of that and the mens rea, all of those things. See if all the boxes have been checked and it's a prima facie case that is available to you without having to rush the process. The downside of rushing the process is that once the truth comes out, as it has so far, you are dealing with a situation or a backlash rather of when now the accused persons are saying, oh, you took me to court on false information and I've been saying this and you weren't listening. Now it's out there. So what does that mean? It means now the state is possibly looking at civil litigation, and the civil litigation is going to lead to unlawful arrest, unlawful detention, unlawful prosecution. That's millions and millions of rands that now have to be possibly paid to these people who were put through something they should not have been put through in the first place. So IDAC, I believe, in working hand in hand with the SAPS, alternatively the Hawks, and also with the NPA, there has to be a bridge of knowledge, because what I've seen, at least in practice, is that when we are busy with trials, for example, and you're cross-examining a police officer, they rely on their practice, their experience or hands-on experience, and they don't know what the applicable law is, what the applicable case law is, and that's where the state loses some of their cases. Alternatively, the state doesn't always check if the investigations were fully done properly, and then when cross-examination comes, we see that certain chain evidence doesn't exist. All of those things, there has to be a way for all of them to work together, be able to check on each other so that justice can actually be seen to be done and not be what we find ourselves in today.
Do you agree with that, Kenny, from what you've observed about what has been exposed here?
I would add to it to say that the checks and balances, to me, is more about the exercise of the power, because if you look at the emails that Ramsamy brought with her, even the investigators knew that the referral affidavit didn't meet the kind of requirements in order to leap to that authorization. What actually took place is that those powers were subverted, and even in some instances you saw that the chief IDAC investigator almost had more powers than the ID in terms of how they were deciding things that should take place. So at all times it shows, at all material times rather, it shows that the prosecutors and the investigators knew that something was off. They knew that this particular referral affidavit didn't meet the pass mark. However, it seems that certain individuals were determined to continue with the matter, even if they didn't have any legal factual basis to do so. And those are the checks and balances that need to be applied, because the structure is there. It's just that there's too much of a loophole or powers afforded to certain individuals in order for them to allegedly abuse those powers. And that is where the reforms must be, to be able to guard the exercise of those powers, because IDAC is quite an important institution in that they have both the investigative and the prosecutorial powers. And if you have one person using that as part of an alleged tool in a subfactional war, that becomes the issue. The structure was there. What the evidence shows is that it was abused in order to serve particular alleged interests.
Very interesting indeed, and a lot more to say about this. Coming up, we're going to find out how difficult a place IDAC was to work at. Stay with us. Welcome back. We continue our analysis of the IDAC media briefing earlier this evening. Difficult not to tie what's been said at the Madlanga Commission to the sweeping changes being announced at IDAC. Just today, IDAC advocate Dushyantha Ramsamy spoke of some of the structural issues that have plagued IDAC.
I have to set the record straight at the onset regarding Advocate Andrea Johnson's testimony before the Commission. Advocate Johnson told many untruths about me and my involvement in what is now known as the Mukwele case. She did not disclose that I raised concerns from the onset and repeatedly thereafter, which concerns I deal with in detail. These concerns are not limited to the Mukwele matter. I had concerns about the crime intelligence-related cases and matters relating to the National Commissioner, General Fani Masiamola. If you have to go and check the records at the wellness program that NPA provides for its employees with regards to just work stress, home stress, counseling, you will be shocked at the amount of prosecutors and employees, admin staff from IDAC that are receiving counseling. If you don't follow the instructions, you receive emails of a nature that, when I was consulting with the DPCI officer, when I intended on making protected disclosure in June last year, I likened it to being treated worse than scullery maid.
Wow, that was pretty harsh. But I think it gives you a real sense of the toxicity that many people experience in the IDAC workplace, Canny, and the fact that staff didn't feel they could contradict Andrea Johnson, stand up to her, not least because she seemed to have been protected by Shamila Batohi.
Absolutely. I think she referred to her as the golden child, I think it was Johnson, to Advocate Shamila Batohi, and how the structure is designed in which these prosecutors didn't have direct access to Advocate Andrea Johnson. It seemed that they were taking instructions also from Dylan Paramal, who is the chief IDAC investigator. And I think how she described it is that if you were dare to challenge the instructions, which were quite unlawful if you look at them at the face of it, then of course they would feel that wrath, which results in that protected disclosure that she tried to make, and all of these revelations coming out as Advocate Andy Mutibi takes office as the NDPP, and Advocate Andrea Johnson has since resigned. So it's become only a safer space for her to address these allegations. I'm not sure if she would still have been in the position to do so if Advocate Andrea Johnson was still in her post and these suspensions didn't take place, or there wasn't a platform like the Madlanga Commission to lay out all those cards and lay the information bare for the Commission to hear the kind of alleged unlawful and improper conduct that had engulfed this particular unit.
And of course, important to note that among the various announcements tonight, Dylan Paramal's suspension was also announced.
Quite a few people have been suspended within IDAC, and it was necessary because even after the allegations surrounding Sunil Belichin, which were made by Witness N, we did see that Kat Madlanga made an appearance before court, and it seemed that the team was still there. And there were several questions raised about the alleged credibility of these particular matters. And now you're seeing that key role players such as Brian Padeachi, Sunil Belichin, Dylan Paramal have now been placed on suspension. And that removes that erosion of public trust in some of these matters that are currently still in court while others are under review?
Of course, Mr. Ngwema, the Minister was at pains to say that the demographic representation at IDAC is sound. There's no racial motivation for the way IDAC staff of Indian descent have dealt with African staff. Do you buy it?
Yes, I have no doubt. Look, there's one thing that if Sipho and his friends who speak the same language may connive and do something that is against the law. I know, for example, a number of other deputy directors in that office who are of different racial groups. I also know people of other races in that particular group. But I think what also emerged today, even if we're trying to entertain issues around ethnicity, is the fact that there's a witness today who may, in one way or the other, be described as falling within that group, but who stands against those particular. But my understanding of those 146 people who are in that unit, the demographics are fairly represented. But I think we shouldn't look in terms of the allegations of this particular group of people and think that this is IDAC population. But I think what we need to do and what we haven't done well is to look at the entire structure of that particular institution and to look exactly what is the leadership structure. How do these allegations that we hear about now, how did they take place? Whether or not is it something that can be corrected? And I think with some of the changes that are being pronounced, but also the investigations that are people going to make, they should be able to understand how this thing works. But I suspect it worked outside those structures that are there. It was not something that was conventional. And I think that with time, we should be able to get a clear picture of what has happened. But I have no doubt it is not something that is driven by ethnicity. It is not something that is driven by racism. But I think there are certain coincidences that would have taken place for certain people to be able to work together.
Advocate Khan, this issue of conflicts of interest came up. In some situations, you'd have colleagues literally investigating colleagues. How does IDAC ensure that doesn't happen again?
Yeah, conflicts of interests and, reporting upon colleagues. I mean, this goes, to my mind, to a matter of institutional trust. And as Kanye said so eloquently earlier, of course, that is also vital for the broader public trust. How does one avoid that or navigate that? I feel like I'm getting hard questions here, I'm sorry, but I suppose one needs very open leadership that doesn't, and this is again, I'm not going to make any sort of personal comments here because I'm not well placed to do so, but simply to state that at the end of the day, it's all very well to talk the talk of integrity and accountability. We have to walk the walk, and we need to create a culture of trust, and we need to live the constitutional values that have, were so hard fought for and won. So it's all, of course we can have codes of good practice and ethics, and obviously now there's greater emphasis on ensuring that there's vetting and the requisite expertise, but also we need to have to live the open door policy of accountability, responsiveness and openness, and that tone is set from above in general, as we've seen within institutional structures in our constitutional ecosystem. So that is the one point. I mean, just to go back to the earlier point regarding this is the flip side to every coin. One of the points so well made, and this links to your question now, regarding the sort of potential dangers in having both investigative and prosecutorial powers concentrated within one body. As we've now seen, this can of course lead to, when you've got a concentration of power, there's always going to be the potential for abuse, but there's always going to be the potential for abuse whenever there is a public power in place or a power in place. But just to clarify, and I think it's important at this point also in the context of what you just asked, that part of the motivation and the legal reasoning or rational reasoning behind that structural design was, of course, to expedite prosecutions, so to ensure that the one arm is speaking to the other in a legitimate sense, such that you can get evidence prosecution ready and properly gathered. And as was stated previously, I think by Ntsabi Singh, or it may have been Kanye, forgive me if I'm wrong, but in the context of ensuring ensuring that, you know, the latest case law is properly understood. I mean, there are still many commentators out there that do not understand that Glenister 2, for example, contemplated a variety of integrity and accountability mechanisms, although alluding to one, it certainly didn't stipulate that there should be one and only one. And I, for one, excuse the pun, do not think that there should be simply one and only one. They need to speak to one another in a not in a synergistic manner necessarily, but in a complementary manner in ensuring the overall constitutional project is managed. So just to go back to your point about trust and exposure, you know, that I suppose in large part comes down to personalities, but the right personalities must be put in place and people need to be properly vetted. And that goes to the broader requirement for structural, operational, as well as public perceptions of independence, being that the people, particularly at the helm, have to have the requisite expertise, but also, as the repeated line goes within our constitution, they have to be both fit and they have to be proper. And they have to live the values of integrity and accountability. They have to take their oaths of office seriously.
A very quick one from you, Ms. Dubazana, security management. Advocate Matibi speaks about ensuring that witnesses, whistleblowers, investigators and prosecutors can be adequately protected going forward. How central is that to a well-functioning IDAC?
I think it is extremely important because it gives the confidence that I am able to actually execute my duties as an employee of IDAC. And usually the people in IDAC and NPA are usually people who are officers of the court. There's the people going to be going to court and prosecute people, you know what I mean? So if I do not have the confidence that I can, quote unquote, tell on my colleague who's not upholding the same kind of ethics that we're expected to uphold, then what is the point of me being here? Why would I be the one who's continuously upholding the law, upholding the rights and ethics, all of those things that I'm supposed to, and yet all of my 10, 50 colleagues are not doing so? So when I speak up, I'm going to be targeted in one form or another. I'm going to be iced out, for lack of a better term, like the witness today in the Madlanga Commission was saying that she's then put on the side. So what is the point? So I think it is extremely important that protection is given. Besides being the work part, there's also the mortality of it. We've seen in the past few years lately, not only people from the NPA or IDAC or even SAPS, but also private attorneys. They have been shot down dead in the streets for being able to speak out or even challenge the institutions themselves. So if these protections are not guaranteed in the most absolute way, we will not be seeing ourselves having the same kind of Madlanga commissions in the future that are going to allow us to see the justice coming forward and having people who are then giving evidence behind closed doors or in camera because they are scared genuinely for their lives. So I think it is extremely important it's done.
All right, thank you very much for that. And we're going to take a short break now. When we come back, we ask what next for the National Prosecuting Authority and IDAC. We're back with the final segment of our programme, and as we look to IDAC's future, let's remind ourselves of former NPA head Shamila Batohi's exchange in Parliament regarding the obstacles to the NPA's success.
The National Prosecuting Authority has not been the subject of institutional review. The Zondo Commission looked at this issue for a long time. I'm aware that there was a lot of investigations that went into it. A number of, it was a time that I was not in South Africa at the time, but I'm aware that a number of prosecutors and other staff members of the NPA made statements, deposed to affidavits in the context of the Zondo Commission. But sadly, the Zondo Commission did not make any recommendations about systemic weaknesses within the criminal justice system.
So, Kenny, there we have Shamila Batohi speaking about the difficulties that the NPA faced, right? And clearly IDAC has faced the same problems, resources being one important issue there. What is likely to happen in terms of the IDAC's future within the NPA? I mean, clearly they're not disbanding it, nor is there appetite, seemingly, for a Chapter 9 institution set up where they operate entirely on their own.
And if you look at the briefing from the NDPP and the Justice Minister, it's quite promising in the sense that you don't get the idea that they feel that this is the end of IDAC. In fact, they are looking at tools to strengthen this particular unit, because you do need a body that will be able to fight the high-level complex corruption cases. And that's usually where the criticism falls for the National Prosecuting Authority as a whole. It's not really about other cases that fall in different categories. It's these cases that emanate out of the Zondo Commission, where it's seen as persons are powerful, they sometimes can appear to be above the law. It's conquering those cases that the public wants to see, and it's about getting IDAC back on track to dealing with those cases, because if we're quite frank about the evidence at the Madlanga Commission, they had no business involving themselves in these matters, and it seems that they may allegedly have been a sinister motive behind that. It's about getting IDAC back on track in terms of its mandate.
So Advocate Khan, and I'm going to ask all our guests for a slightly short answer here. It's always a gallop to the finish on a case in point. But the terms of office, Advocate Khan, being limited to a particular period of time versus the IDAC head being permanently appointed, is that an important development?
When you say terms of office limited to a certain period of time, you're referring to the relevant personnel as opposed to the IDAC itself.
Exactly. So yes. I'm saying
yes, of course.
A short period of time versus, you know, and then someone else takes over versus someone being permanently employed in that position.
Yes, absolutely, Jan. I mean, that is vital. You know, obviously the institution itself, structurally, you know, it's there, but the people have got to prove themselves fit. They get appointed. Of course, security of tenure is vital, but equally they can't just be this extended long period of time. I mean, if I can just draw an analogy, if I think of the old Justice Alliance case regarding the extension of the former Chief Justice Nobo's term of office, you know, he was a tremendous Chief Justice by all accounts in terms of his jurisprudence and his leadership, but at the end of the day, it's about the public perception of impartiality. And so, just as like no judges above the law, equally should no relevant leader and/or employee at the IDAC be above the law, and therefore security of tenure is important. But at the same time, balancing that with the length of time in terms of the appointment and the fitness for purpose for that office, equally so. I hope that answers your question.
Yeah, I think it does. Thank you. I mean, and Ms. Dubazana, let me bring you in here. This issue of resources wasn't really addressed at the media briefing today, but it has been said multiple times that IDAC doesn't have enough hands to be effective, and I think we know that's a wider NPA problem, isn't it?
100%, it really is a serious problem. Already as it is, if you just go to the lower courts, let's not even go to the high courts, just the lower courts, the prosecutors are inundated with dockets. And it's one person versus 150 dockets or more sometimes. And as a result, they have to make sure they're on top of the game, make sure that the dockets are ready for trial and that complainants and victims are assisted as best as they can. But they do not have, apart from human resources, they do not have the actual legal resources that they need. Unlike when you're in private practice, for example, you have access to things like LexisNexis, you have access to Safely, you're able to read up on the law and you are sitting in court and you're able to address the presiding officer. So if that kind of training, that bridging of the gap can be done, I think the NPA will be extremely successful, because you'll be able to actually put the law to the facts, and you'll be able to make sure when you say there's a prima facie case against an individual that everything is actually aligned, and you're possibly going to secure conviction for your particular case. So I do believe resources has to be both human and also the intellectual or educational part. Merge those two together and see magic happen.
All right. A very, very quick one from you, please, Mr. Ngwema. A 6-month turnaround, is that possible?
Look, it's a very difficult one uphill, but I think that there's a low-hanging fruit that they can be able to do. For example, the things that we are talking about in terms of resources, but also they should also be able to recruit from outside. I don't think the packages that they offer for now, they can be able to recruit most of the skills from the outside, because they lost those skills when they disbanded some of the structures. But I think that there are things, as I said, in terms of low-hanging fruit that they'll be able to achieve to turn the thing around. And also Advocate Mutibi is new, and therefore it's an opportunity for him to be able to make sure that he puts the foundation of his visions up front.
Kenny, I don't suppose media want to hazard a guess as to who the next head of IDAC is going to be, do you?
Your guess is as good as mine at this point about who could be the possible acting IDAC head, but it's going to be quite the task as the lens of scrutiny is now on this particular unit as they continue with this task of fighting high-level corruption.
Well, thank you so much for your insights there. SABC News reporter Kenny Mapanga, Advocate Con, Mr. Ngwema and Ms. Dubazana, thank you so much for your insights into this fascinating story. Well, every week we bring you a new fact about the law. Did you know that if you experience such an abuse of authority by either a prosecutor or a member of IDAC handling your matter, you have the right to submit formal written representations to the National Director of Public Prosecutions or the relevant Director of Public Prosecutions to review or set aside unlawful decisions. Approach the High Court for a declaratory order or a permanent stay of prosecution if the abuse violates your constitutional right to a fair trial. Lodge a complaint with the Legal Practice Council to request an investigation into the professional conduct of specific prosecuting advocates or legal professionals. In the case of IDAC, you can file a direct complaint of maladministration, abuse of power, or improper behaviour with the IDAC Ombud. And before we wrap up our show tonight, if you're facing a legal or justice issue that you'd like us to explore, please email us on caseinpoint@sabc.co.za. And that is a wrap from us for tonight. We'll see you again, same place, same time next Thursday at 8 p.m. from the Case in Point team. Take care till then. Bye-bye.